All right. So what I wanted to go over on this video is this case, right? It's dealing with the 11th Circuit, and they ruled that consumers can recover statutory damages for willful Fair Credit Reporting Act violations without proving actual damages, right? Normally, under the Fair Credit Reporting Act and just a different consumer case law, if you are looking to sue the credit bureaus, normally they would say like you have to show that you was actually damaged by the negative information that was on your credit report. But this case proves otherwise. And this is a good thing for consumers because now you can sue basically just because you have negative information on your credit report. So you need to be able to find what's inaccurately reporting on the account that you're trying to get removed, right? So this is the point of this whole video. So it says that joining every other circuit to address the same issues, the U.S. Court of Appeals for the 11th Circuit recently ruled that a consumer does not have to prove actual damages to recover statutory damages of willful violations of the Fair Credit Reporting Act. So what that means is, according to the law that you would use to sue the credit bureaus, you don't actually have to show that you was damaged because of that information, because just the fact that the information was inaccurate on your credit report shows that you were injured, right? So this case is Omar Santos et al. Versus Experian Information Solutions. And they said the named plaintiffs filed a class action lawsuit in which they sought to represent a class of individuals whose credit reports contain trade lines for debts reported to Experian by a collector of medical debts, healthcare trade lines, right? It says, due to a technical error by Experian, the status dates for the healthcare trade lines reported by Experian on the named plaintiff's credit reports were inaccurate. So what it's saying is the status dates were wrong. Status date is the date of last activity, right? Which corresponds, it depends on what kind of credit report you're looking at. But if you're looking to find what the status date is, and you pull your Identity IQ credit report or a 3 bureau credit report like Smart Credit, My Score, Identity IQ, one of those, which are easier to use to find inaccuracies, you're going to be looking at what's called the date of last payment, or the last payment date, or the last reported date, right? The last reported date, really. The date of last payment too, and you want to compare those dates with the payment history. We'll go over a brief sample dispute credit report that shows something similar to what I'm talking about. But it says the named plaintiffs were among more than 2.1 million consumers whose Experian credit reports provided to third parties had inaccurate status dates for healthcare trade lines. In their complaint, the named plaintiffs alleged that Experian willfully violated its obligations under the FCRA to follow reasonable procedures to assure that the credit reports were prepared with maximum possible accuracy, right? So that has to do with this section of the Fair Credit Reporting Act, right? So let's look at the FCRA. Is dealing with Section E, compliance procedures, subsection B, where it says whenever a consumer reporting agency prepares a consumer report, it shall follow reasonable procedures to assure maximum possible accuracy, which is what they're suing for, because the bureaus didn't follow that. In most cases, the bureaus don't follow that when it comes to information that's on your credit report. So this is why we use that if we find inaccurate information, to get the account removed, right? Or deleted from the credit report, because that's what it says. If you find or you make the bureaus aware of inaccuracies, they're supposed to do an investigation, and upon finding out that that information is actually inaccurate or unverifiable or incomplete, they have to delete it from your credit report. But what happens is the bureaus end up verifying the inaccurate information as actually being accurate, which is against the law. It's totally wrong, but they do it all the time. But this is why I teach you guys to sue the credit bureaus, how to dispute using factual information that's on your credit report that cannot be disputed if you have to go to a jury trial or you have to go to court, because they can dispute it all they want if you're going back and forth with the bureaus. That's what they're going to do. But until you hold them accountable in a court of law, you can use those dispute letters where they kept verifying things, and when you pull your credit report, it was still inaccurate. You can use that as evidence against the bureaus to prove that they didn't follow reasonable procedures to assure maximum possible accuracy. And with this case, what it's saying is you don't have to prove actual damages, because again, they would say, oh, well, even if it was negative, which is what they're going to say here, Experian, you weren't actually damaged, so this is where this case really comes, this is where it really comes down to, right? So it says They didn't follow reasonable procedures to assure maximum possible accuracy. It says they sought damages of no less than 100 and not more than 1,000 for experienced willful violations. Now, that section of the Fair Credit Reporting Act, where it deals with the amount that you can sue for willful noncompliance, is dealing with 1681N, civil liability for willful noncompliance. Is dealing with this section here, A1A. It says that any person who willfully, when they say person, they mean a credit bureau or a lender or furnisher, who willfully fails to comply with any requirement imposed under this subchapter with respect to any consumer is liable to that consumer in an amount equal to the sum of this. It says any actual damages sustained by the consumer as a result of the failure, or, and that's the key, or it says damages of not less than 100 and not more than 1,000. Right, so that's what they're suing for. Not less than 100, but not more than 1,000. Right, that's right here. They sought damages for not less than 100. Right, so now it says Experian. They moved for summary judgment. Right, it says while it did not dispute that the named plaintiff's credit reports contained inaccurate status dates for the healthcare trade lines, it argued that the Fair Credit Reporting Act provision for willful violations required the named plaintiffs to prove that they were denied credit and incurred actual damages as a result of the inaccurate dates. Again, inaccurate dates. This is why I teach you guys, when you're analyzing your credit report for errors, you want to use or go with any inaccuracies that you find with those dates, especially the dates like that are close to like the end of the account, like the date of last payment, the date of last activity, the last report date. The open date isn't really like, it's not a big thing. I mean, it is a big thing. It does count. And, so you want to always target dates and stuff like that. And you want to cross-reference those dates with the 2-year payment history. So if it's saying that is the last payment date was XYZ, or the date of last, or the last report date was XYZ, you need to look on the payment history, the 2-year payment history for that bureau, and make sure that that's what's reflected in the 2-year payment history, as well as, the actual date. I mean, again, most times it's completely wrong. And again, what they're saying is, again, Experian did not dispute that the credit reports contained inaccurate dates. What they were disputing is that the provision for what they're suing for, or what they're suing under, requires them to prove that they were denied credit and incurred actual damages as a result of those dates. So it's like it has to be wrong. They're saying that it has to be wrong, and you have to have suffered some sort of damage. That's what Experian is arguing. The court in this case is saying, no, that's not the case. They don't have to suffer actual damages by getting denied credit, right? Which is the premise that I always was under, and that I kind of taught you guys as well. But again, this case is saying that, no, that's not the case. All you have to do is prove that there was inaccuracies, because the inaccuracies are the actual injury to the consumer, right? And it says the district court agreed that proof of actual damages was required, but denied Experian summary judgment motion because there was some evidence that the named plaintiffs suffered actual damages. So the court that actually, because this actual case, what we're reading from right now, has to do with an appeal. So they appealed the judgment, because going through the case, the district court actually agreed with Experian and ruled against the plaintiff. So the plaintiff had to appeal it, and they appealed it to this the appellate court of the 11th Circuit, and they remanded it back. They basically said, well, the district court got it wrong. They can't go with Experian. They have to go with the consumer, right? And so it says, after the close of the discovery, the named plaintiffs moved to certify a class, and as to the predominance requirement of the Federal Rule of Civil Procedure 23, they argued that because they did not have to prove actual damages resulting from Experian's willful violation, any individual issues concerning class members' actual damages were irrelevant, right? So basically, they were saying that they was arguing against Experian. They're like, we don't have to show actual damages based on the predominance requirement under Civil Rule 23. We don't have to do that, right? It's irrelevant to what we're arguing. And it says, in response, Experian argued that because the putative class members were required to prove they were actually injured by willful violation, each class member's individual proof of damages would predominate over common questions. Right. So again, they're arguing against the plaintiffs, right? Then it says the magistrate judge agreed with Experian that the named plaintiffs had not met the predominance requirement under Rule 23 based on the district court's prior ruling on Experian summary judgment. So again, the court went against the complaint, the plaintiffs, and went with Experian, right? And again, this is why this case was appealed to the appellate court of the circuit, 11th Circuit. It says the magistrate judge recommended denying the named plaintiff's class certification motion, and the district court adopted the magistrate judge's recommendation and denied the class certification. The 11th Circuit then granted permission to the named plaintiffs to appeal the district court's class certification order. So again, this is what they did. They appealed it. And now it says relying on U.S. Supreme Court's 2021 decision, TransUnion versus Ramirez, the 11th Circuit first found that the named plaintiffs had Article 3 standing to bring the action or to bring the lawsuit. Article 3 standing, basically, you can sue in federal court or whatever, right? So it says specifically the 11th Court referenced the Supreme Court's acknowledgement in the Ramirez TransUnion case that intangible harms can be concrete if they bear a close relationship to harms traditionally recognized, providing a basis for lawsuits in American courts. Again, so in that case, they were saying that you don't have to, as long as the harm is closely related to something that could cause a concrete harm, basically it has standing, right? And it says, according to the 11th Circuit, because violations of the FCRA have a close relationship to the harm caused by the publication of defamatory information, a consumer does not have to prove that the false reporting caused an injury because the false reporting itself is the injury. So what they comparing the publication of your credit report with false information on it is what they call like libel or defamation of character, right? So if somebody published something like, something that was wrong about you somewhere, it's akin to the same thing. That thing is the injury, right? That the fact that information got out there and it's false, it's causing you harm. You don't have to actually go into so it's like if somebody spread a rumor about you in your community that you're a thief, you're a liar, you've been to jail, and none of that is true. You don't have to actually go out into the community and experience like being denied services because somebody spread that rumor, right? Like the fact that person did that and can't actually prove it holds that person liable. It's the same thing with these credit bureaus, right? You don't have to go apply for something and get denied to prove that you were harmed because of the false information on your credit report. The false information on your credit report is enough, right, that it causes the injury itself, right? So that's pretty much what they're saying, right? So it says the 11th Circuit found that the named plaintiffs had standing because the record contained evidence that the status dates reported by Experian on the credit reports were inaccurate, right? So it's not like they can get around it. So so just for example, let's look at this particular account, right? When it's talking about the status date, it's talking about the date last active, right? It could also include the date of last payment as well, right? Typically, the last payment date is the date that starts the delinquency of the account. But sometimes it won't go into delinquency at that point in time, right? So we look at the date last active. Now, if we look at what TransUnion has, it's showing 3/12/2021. So again, like I tell you guys, compare it to the 2-year payment history, which is this section down here. Now, it doesn't even go back to 2020, March 2021, right? It only goes back to September 2021, right? So, and then there's still activity. So how could this be the date last active if it's showing activity after that date? Now, if we look at what Experian is showing, it's showing the date last active of February 1st, 2022. And if we cross-reference that date with the 2-year payment history, we see that on February 2022 is the first time that it went into charge-off status. So that should be the date that's last active because it corresponds with the other data that's on this credit file or credit report, right? The other information that's here. So obviously, TransUnion is reporting an inaccurate date last active. It's reporting an inaccurate status date, just like this case is in this case. So you would want to challenge that date with TransUnion in hopes that they would correct it or remove this account from your credit report, depending on what you request them to do. Normally, if it's a charge-off account like this, it's already negative, it's closed, you want it removed. So you want to request it removed after you point out what's inaccurate about it, which in this case is the date last active or the status date. So in your dispute letter, you would put, dear TransUnion, I'm reaching out about this JP Morgan Chase card. The account number is blah, 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 blah. The balance is $22,000, and you're reporting an inaccurate status date or an inaccurate date last active. You have 3/12/2021. And then the other thing about TransUnion is when you look at the 2-year payment history, they don't even have information here that you can use. Right, Experian has the 2-year payment history information here. So again, you would let them know that the date last payment of 3/12/2021 that they have listed is inaccurate, and you're asking them to investigate it and delete it from your account. Now, if they verify it as accurate, sue them. Make them prove it now, because clearly you're not maintaining procedures to assure maximum possible accuracy to information on my credit report. Now, granted, TransUnion is pretty good at updating information or correcting things. It's Experian you really got to worry about a lot of times. They're the most named credit bureau that's always in some stuff, cases brought against them. So you point that out. Again, if they verify it as accurate, you have grounds now to sue them, just like this case that we're going over, right? So back to the case. It says the Fair Credit Reporting Act in 15 U.S.C. 1681 in A1A, which is, again, what we just looked at, right? This is 1681 in A1A, right? It says it allows a consumer to recover, number one, any actual damages sustained by the consumer as a result of the violation, or two, damages of not less than 100 and not more than 1,000. Experian argued that Congress made recovery under both options contingent on a showing of actual damages, and that damages under the second option are reserved for consumers who incur actual damages but neither cannot prove the precise amount of the damages or suffered less than 100 in actual damages. So again, Experian is arguing that that particular section that allows consumers to sue them for damages requires them to prove that they were actually harmed, or there was some actual damage, that they got denied credit, something like that, right? That as a result of that information being wrong, you couldn't access credit, you couldn't get a credit limit increase, you couldn't co-sign for somebody, you got denied your mortgage application, you got denied your refinance, right? They're saying that you have to experience something like that in order for this section to hold true. Again, the appellate court comes back and says, no, that's not the case. Consumers don't have to prove actual damages. And again, this is a very, very important thing to understand as a consumer if you're disputing information on your credit report, because if you don't know how to sue the credit bureaus, you'll just be in a never-ending cycle of going back and forth with them, and they'll just keep verifying the information is accurate when you could have been taking them to court and prove that, hey, you guys are in violation, and I'm going to sue you for not less than 100 or 1,000, right? So it says, in rejecting Experian's argument, one of the key rationales offered by the 11th Circuit was the plain language of Section 1681 in A1A with regard to the first option, which states that actual damages must be sustained by the consumer as a result of the violation before the consumer can recover. In contrast, the second option contains none of these requirements. So under the second option, the court is admitting, the appellate court is saying, you don't have to prove actual damages. It says, in addition, emphasizing that the two options in Section 1681 in A1A are separated by or, right? The term or. It says the 11th Circuit observed that Congress's use of the word or to separate two provisions in a statute signals that there are two alternatives, and that reading the second option to allow for statutory damages without proof of actual damages gives the option separate meanings. So in essence, Experian is trying to superimpose the first option, right, and its requirements onto the second option, right? There's no need for that. It doesn't require that, right? So, and again, they're not suing under the first option. They're suing under the second option, right? So, it says the 11th Circuit observed that its reading of the Fair Credit Reporting Act was consistent with its FCRA case law and with how other circuits have read Section 1681 in A1A. It says the 11th Circuit cited two decisions of the 8th, 7th, 9th, and 10th circuits, which held that the second option of Section 1681 in A1A does not require proof of actual damages. Accordingly, the 11th Circuit found that the district court's denial of the named plaintiff's motion for class certification was an abuse of discretion because the district court's analysis of Rule 23 predominance requirement was based on its interpretation of the second option in Section 1681 in A1A. It says the 11th Circuit vacated the district court's decision and remanded the case to allow the district court to address Experian's argument that the named plaintiffs did not meet all of the other Rule 23 class certification requirements. And you can actually take a look at the case if you want. It's here. I'll probably include the link to this actual article. The article's a lot shorter than reading the actual case. The case is pretty long. I'm still reading it myself, but I wanted to go over this because, again, you want to dispute your credit report looking for inaccurate information and be able to hold the bureaus liable for the violations when they don't correct them, right? When they just verify, because they use an automated system and they do this all the time, right? You may get results and see deletions, but normally there are stubborn accounts that they just verify willy-nilly and they're actually still inaccurate that you can get paid for damages for. And you don't have to prove any actual damages. Right? The fact that it was on your credit report, it was wrong, you let them know that it was wrong and they did nothing about it, you can sue them for that. And this is my point. This is what I really teach. So if you are interested in, disputing negative information on your credit report and being able to put yourself in a position to sue the credit bureaus for these type of violations, you want to get my software, right? You want to get signed up with Credit Coach DIY so that you can so that you can dispute your credit report. Credit Coach DIY does everything for you, right? So it imports your credit report, it analyzes the credit report for you for negative accounts, and then it gives you the actual dispute reason to use to get that account removed. It finds what's actually inaccurate on the account. So you don't have to do the analysis yourself, which could take you 30 minutes, an hour, 2 hours. It could take you all day. This does it in minutes, in the click of a button. Or a few buttons, right? So to get started, all you got to do is create your account, add your profile, and download your credit report. It's $39 a month. You're not gonna need it for that long, right? Like you may need it for a few months, but it's gonna help you along the dispute process to put the proper letters together, right? To put yourself in position. Again, the software does everything for you. And if you're interested in watching the tutorial video for the software, I'm going to attach the link here as well. So you can watch the tutorial video so you can learn about the software, see how it works, see if it's the right fit for you and get signed up. We also have ebooks, courses that you can use if you're interested in that, with dispute letters along with them. If you really want to do it manually, if you want to save yourself the time and the effort and everything, definitely get with the DIY program because it's going to put the dispute letters together for you. Right. And we have a slew of other things as well to help you along the way with your credit report. So appreciate you guys. Tap in with me, drop some comments, and connect with me if you have any issues. All right. Catch y'all later.